Good afternoon and welcome everybody to this webinar on the retained EU law revocation and reform bill. Now that's quite a mouthful and has no obvious acronym, so hereafter we'll refer to it simply as the bill. I confess, tempted to suggest the restrained EU law bill, as its core purpose, as we shall see, is to restrain the effect of retained EU law and EU law in domestic law. Or perhaps even better still, the hokey-cokey bill, as there's a lot of left legs in, left legs immediately out again, and a considerable amount of shaking it all about, again, as we shall discuss on this webinar. I am absolutely delighted to be joined in that discussion, or perhaps that dance, by Philip Moser KC and George Peretz KC, both of Monkton Chambers, and Professor Barnard of the University of Cambridge. Welcome all. To stimulate different insights and views from each of us, we plan to run the session as a bit of a free-flowing discussion, we hope, rather than the usual one topic and one speaker format. To give some structure to our discussion though, I am going to guide us through the topics in turn, starting with the sunset provisions and the ministerial powers to restate or modify retained EU law. And then we shall discuss the bill's provisions on retained case law and the new national reference procedure, which has got Philip very excited, before turning to the substantive changes coming from the end of 2023, such as the abolition of supremacy and general principles of EU law, and the creation of a new category of law, as if we didn't have enough already, assimilated law. And we will conclude with some thoughts on the application in the devolved nations as well. We'll obviously try to make the discussion as accessible and clear as possible whilst you eat your lunch, but it may be wise to have a copy of the bill to hand or on screen whilst you listen in. And finally, I should also remind you that there is a Q&A box. Please do put any questions in there, and time permitting, we shall address them either at the end of each topic or at the end of the session so that we don't get stuck along the way. So without further ado, let us begin with the sunset provisions in clauses 1 and 3 of the bill. I wondered, what is the sunset, Catherine, and what exactly does it cover?
Well, thank you very much indeed for the invitation to be here. I must say, I think we're all feeling somewhat apprehensive because this is our first bite at what is an extraordinarily complex piece of legislation. I mean, the headline of the bill is sunsetting. And if you read no further than clause 1.1 of the bill, you would be led to believe that all EU law would be sunsetted, retained EU law would be sunsetted, i.e. turned off by the 31st of December 2023. But as we say to all students, don't just stop at clause 1. You do need to look a bit further. Now, just before I go into the caveats to what I'm just about to say, we should just be clear about what is being sunsetted. Most importantly, EU-derived subordinate legislation. Now, this is very difficult terminology, but essentially what you're talking about there is things like the working time regulations. So legislation adopted primarily under Section 2.2 powers of the European Communities Act. But in addition, also meant to be turned off, retained direct EU legislation, which would be things like the passenger rights regulation. Also, thirdly, being turned off is directly effective rights. So things like treaty provisions, of which there are very few left, but one of them would be Article 157 on the principle of equal pay for men and women. Note, crucially, what I have not included in that list is Acts of Parliament. Acts of Parliament are not being turned off in this sunsetting, contrary to popular belief. And this is partly, I think, due to Jacob Rees-Mogg, who has been taking this bill or will take this bill through Parliament and has been doing all the prior work on the bill. He believes Acts of Parliament are indeed the highest point in our constitutional system and therefore should not be subject to this sunsetting process. So things like the Equality Act 2010, which contains a very large number of EU-based provisions, is not affected by this sunsetting. So point 1, there is a huge sunsetting clause, and that is clause 1.1. But you need to look at clause 1.2. Clause 1.2 allows ministers or the devolves to protect their legislation from the sunset, provided they make regulations to that effect. Now, that would mean that if BEIS were to decide to save the working time regulations, they would need to adopt regulations under clause 1.2 and therefore the working time regulations would continue in effect. And we think, although there's some debate on this point, but we think that any legislation which is saved under clause 1(2) is not subject to the further sunsetting of the 23rd of June 2026. So that's the clause 1(2) exception to the sunsetting, and the clause 1, then the other exception to the sunsetting is clause 2, which you can delay the sunset till the 23rd of June 2026. But frankly, why would any department use that clause 2 when you've already got clause 1(2)? And I'll stop there.
And on clause 1(2), which essentially allows certain legislation to be exempted from the sunset as you set out, George, does that mean that different devolved nations, because of the use of the phrase relevant national authorities, can make those regulations? Does that mean that different devolved nations can have different applications of this principle, and so there's divergence between the different nations?
Yes, short answer to that. Yes, they can. And I don't see any reason, certainly on the face of the bill, why a devolved minister sitting in Edinburgh or Cardiff couldn't even go so far as to say, I'm going to apply clause 1(2) to everything within all RUL that would otherwise be sunsetted within the area of my devolved competence. The only practical check on that will be, though, in many cases, you'll have to start thinking about the UK Internal Market Act, because in a situation where the result of the devolved administration taking an approach that resulted in the regulation being, to put it loosely, somewhat stricter in Scotland or in Wales than it was in England, you would then have to think about what the consequences would be when producers of goods or services which are lawfully put on the market in England then turn up in Edinburgh and invoke the UK Internal Market Act provisions to say, you can't stop me selling or marketing these goods or services here.
And Philip, what else do we think might be covered by this cliff edge? Should we all be very worried by this cliff edge?
Well, I don't know whether we should be worried. It's certainly an ambitious cliff edge, because the idea behind this is that you're going to try and get rid in one fell swoop, at least that's the headline, as Catherine put it. You're going to try and get rid in one fell swoop of the legacy EU law legislation that still sits on the statute book. And I mean, there is something, I think, something historically attractive about that, if you consider that the fulfillment of the referendum and the desire of those, the implied desire of those who voted to leave, involves onshoring not only our sovereignty, but also the laws that derive from it. And you could say, as I think was suggested initially, well, as far as retained EU law is concerned, that will eventually sort itself out over time. First, you onshore all EU law, and then over time, Parliament can deal with it, and gradually EU law will become English law. What this it really is, this bit, I think, is an acceleration and a focusing of minds, because history has shown us that statutes can be remarkably stubborn and remain on the statute book for really quite a long time. The Waste Act 1267 in England is still in the statute book. The Royal Mines Act 1424 in Scotland on the statute. And interestingly, neither of those have been applied to the other jurisdiction after the Act of Union of 1707. And so you see, you have statutes that may hang around for 600 or 800 years or longer, and also lead to divergences amongst the different parts of the United Kingdom. And so it's a radical idea to say, so that we don't have to wait 800 years to get rid of the commercial agents regulations or whatever it might be, or wait for a specific parliamentary opportunity, let's go at it the other way around and say we're going to sunset all of this stuff unless it is specifically saved.
There is a role reversal there, though, isn't there, between Parliament at the moment can, of course, repeal the laws if it doesn't like them. I take your point about pragmatism and time of parliamentary time. But what the bill proposes to do is actually essentially reverse the normal order. They will be repealed unless and until a minister, so the executive, decides to retain these pieces of laws, which is rather odd. It reminds me of the Lord Panic shooting at the target and the effective Article 50 metaphor, that essentially Parliament has shot the gun. All of these laws will by default be repealed unless a minister steps in to save parliamentary laws. Because
I mean, exactly. I mean, I think there is a problem there. I mean, perhaps one would be being unduly cynical to suggest that what might happen as a result of the sunset clause is that government departments might be tempted to turn up to Parliament in November and December 2023 with whole rafts of replacement revocation legislation. We'll be dealing later with how that's done. And where Parliament it would otherwise it is in a position of being able to prevent that because it requires a positive vote in both houses of Parliament to get it through. Again, we'll look at when that's necessary. But when Parliament has essentially got a gun to its head, it's faced with a whole pile of legislation to which there may be pretty substantial objections. But the message is, unless you get it through, I'm afraid the rules will simply fall away. That makes Parliament's position extremely difficult. Now, perhaps one would be unduly, as I said, unduly cynical to suggest that that was being planned, but it's certainly a possibility, if by accident, if not intention, that will happen.
That's one, as you say, potentially cynical view. On the other hand, if it's properly managed, that needn't necessarily happen, and ought not to happen. What is likely to happen, in my view, and I'm sorry if I'm slightly leaping forward to giving away, if not quite the ending, then at least the next stage of this, is that an awful lot of this is likely to be postponed. But the amount of EU retained law and other legislation that's going to be affected by this is so vast, and there are many other things that occupy the government's attention, that they're likely to use Section 2 of the bill at the moment that says that you can postpone the sunset. And we've seen that already in the context of the EU-UK Trade and Cooperation Agreement. An awful lot of things that turn out to be quite tricky to do get postponed. But that is, in my view, more likely than a great queue of things in Christmas 2023.
It's the first hokey pokey, isn't it, Clause 2, really? Because we've been told in Clause 1 we're having a sunset provision, it's 2023. Then that's the left leg in. The left leg out straight away is Clause 2, which, as you say, says that by regulation, the sunset can be extended to June 2026, which is 10 years, I think, from the date of the referendum. So that's the first hokey cokey, really.
That's right. Extending the sunset, which sounds like a BBC sitcom set in an old folk home.
Could I just say that I think the timing of this is immensely tight, because remember, we're talking about a new bill. It's got to get through both the Commons and the Lords. It presumably will go through the Commons relatively easily, but the Lords, it's much less clear. Now, are you going to get to the Lords by Christmas? Possibly, but remember, none of these regs can be laid until the bill has become an act. I know this is a statement of the blinding obvious, but the reality is that there's going to be a crunch now, okay? A well-organised department can get on with drafting the regs in anticipation that the bill will become an act, but there is going to be a very short window, in fact, from between when the act becomes into force and the December 2023 deadline. So I think it's important to bear that in mind, which makes actually George's scenario slightly more likely, that there's going to be a big run on legislation in November, December 2023.
So to conclude,
I just think the other thing that's worth noting is there's no consultation requirement at all for any of these regulations, which of course in one sense makes it speeds things up. but on the other hand, obviously leads to the real danger of the replacement or even restatement legislation, attempts to replicate what's already there, being mucked up in various ways because mistakes that might have been picked up in consultation just go through unspotted until it's too late. So I think that there's a real issue there.
So to conclude on our sunset discussion, it's probably worth very briefly flagging matters of law that are not subject to the sunset. So we already mentioned primary legislation and those that are exempt by clause 1.2. But it's also worth flagging that, of course, this only touches upon retained EU law and not separation agreement law. So the law flowing from the withdrawal agreement. So all of the parliamentary statements saying the whole EU law will be off of our books is unfortunately not quite true because of the effect of the withdrawal agreement. And there are also two references buried in this. Firstly, to Northern Ireland legislation in clause 1.5, which is not subject to the sunsetting, so won't be automatically abolished. And also financial services legislation, which is mentioned in clause 22.5. I don't know whether, George, you had any views on why the financial services legislation is not subject to this automatic default abolition.
Well, I've no inside knowledge on that, but I assume it's because it's thought that the existing powers under the financial service legislation are adequate to deal with what issues there are. I mean, another point it's worth noting, it's nowhere in the bill and it's nowhere in the explanatory notes, but if you look at a Bayes press release issued on the day of the bill, they tell us that it's proposed in relation to VAT and other tax aspects of retained EU law to deal with that separately in finance bills over the next 1 or 2 years. Again, no doubt, because I think it's fairly well known that one of the Whitehall departments with real concerns about all this process has been HMRC, in particular in relation to VAT, which, as anyone who does VAT knows, is largely dependent on the continued application of EU principles and case law in order to make sense of the regime. And I suspect there's been a certain amount of anxiety there about the effect of this bill. So I think that the proposal is to deal with that entirely separately, but there's nothing on the face of the bill that tells you that. You just have to look at the press release.
And it's just worth, just to follow up on what George said, for those of you who've not seen it, it's worth having a look at the Financial Services and Markets Bill, which is expressly referred to, which has express provisions indeed in clause 1 on revocation of retained EU law. So there are explicit powers there to deliver that, which I think is another explanation.
Yeah. Okay, so that deals with the default position then, that unless extended to 2026, a large amount of retained EU law is likely to be abolished automatically. But is that likely to happen in practice? Because there's obviously an awful lot of ministerial powers in the bill, in clauses 10 to 17, to restate, replace and modify retained EU law. I wonder, George, if you would, at a very high level, talk us through the scope of those powers in a few minutes because of the time.
Yeah. Well, there are various things ministers can do. One, which we've already explored, is they can do nothing at all and just let the provisions fall. And there's no parliamentary control over that process. Parliament will have just passed clause 1 and that will be the legal basis for it. There is a separate, slightly odd power at first blush in clause 15.1 to make regulations that revoke the retained EU law subject to the sunset clause. One wonders why that might be needed, but presumably it could be needed if it was intended to revoke the law earlier than the 31st of December 2023. I mean, one thing I was thinking, sort of contemplating over the last couple of days, is what you would do if you wanted to judicially review a ministerial decision not to do anything. Of course, you might have trouble finding a basis for that, given the very wide power. You'd also have some trouble, I suspect, locating a decision, because, as I said, the minister just needs to do nothing at all. So you'd have to try and generate a decision by inviting the department to confirm that it wanted what was going to go on, and hope that the courts would be generous in accepting that a refusal to confirm that the rule was going to be replaced with something else as effectively a decision not to replace it and to let it fall. Right, so that's the do nothing, let it fall set of options. Another thing they can do, which is under clause 12 of the bill is to restate the existing regulations. So that's effectively rewriting them in the sense of trying to say the same thing in common law UK language as the retained EU law instrument means, both on its own text and as that text would be read applying normal EU principles and applying ECJ case law. It's worth looking, when one's thinking about a restatement, it's worth looking at clause 14, which tells us a bit about what restatement means. And it tells us, for example, that a restatement can resolve ambiguities or remove doubts. So that is to say, if there's been argument in the textbooks about what a particular provision of retained EU law means, it's open to the minister simply to legislate for whatever interpretation takes their fancy, and to resolve the ambiguities and close down the debate that way. I mean, essentially the boundaries of this provision, the restatement provision, really in the end depend on what one means by restate. The only thing we're told about what restate means is that it includes, this is clause 12.8, includes codification. That phrase rather suggests that it's intended to go beyond codification. It's not defined as meaning codification, it's to include codification. But there will doubtless be some outer limit to what counts as a restatement, and which will have to be policed by the courts, and they may, I suspect they probably will, take a restrictive view of that, if what actually seems to have happened is what looks like a fairly substantive change. Now, if the ministers choose simply to restate, then that is a regulation that is simply that is goes subject to the negative procedure in Parliament, so that becomes law unless time is found in either House of Parliament to debate the change and the relevant House decides to vote it down. Something which is, as most people know, something that happens extremely rarely. Another thing they can do, this is in clauses 10 and 11, and I'm not going to say very much because they're extremely complicated, and the result rather depends on a whole lot of other statutes. They can use existing powers in other statutes to rewrite or replace the existing regulations. So the current position where general powers, Henry VIII type powers, are disapplied from retained EU law, all go. So where there's an existing power to rewrite and replace, they can now use that. The next thing they can do, this is clause 15.2, is to replace regulations with which ministers think are appropriate and meet the same or similar objectives. So this is now getting wider than restatement. This is doing something different, but to meet the same objectives. I mean, an example I came up with is possibly somewhat controversial, and one could probably easily argue it the other way. An example I came up with, which was if you take the current provisions in the cosmetics regulations that ban the sale of cosmetics tested on animals as an animal welfare measure, a minister might perhaps decide that it was appropriate and would meet the same or similar objectives of animal protection, not to ban such projects, but just to place a warning label on the products that warned consumers that the product had been tested on animals, and let consumers make their minds up. One might take the view that that was an appropriate way of securing animal welfare and allowing consumers, if they wanted to, not to purchase products tested on animals. Now, one could probably argue that particular example cheerfully either way, but it's an example of how wide and important these issues might be. And again, if the ministers use that provision, it's again negative resolution procedure and no need for a vote in either house. Now, the most startling power, which is in 15.3, is the provision that allows ministers to replace existing regulations with whatever they think is appropriate. And there's no requirement that the new regulations bear any resemblance at all to what's being replaced. So to take my cosmetic regulations example, Ministers might simply decide that the whole animal testing ban is entirely inappropriate, and the new regulations will contain no reference, no provisions relating to that whatsoever. Now, if they do that, then the parliamentary procedure is affirmative resolution. But for those who are not familiar with affirmative resolution procedure, it involves a single yes/no vote, no possibility of amendments in either house. And although both houses have to vote on it, the debate is often short and frankly somewhat perfunctory. The discretion that ministers have to make new regulations is not entirely unconstrained, however, because clauses 15.5 and 15.10 prevent ministers imposing regulations that overall, so on balance, impose a new regulatory burden. Burden is then defined very widely. It includes an administrative inconvenience. So something could be quite minor and still involve a regulatory burden. And that shows that this is of course deliberate, the ratchet here is one way. The replacement is to, on balance, be deregulatory. It is not to be on balance towards more regulation. This is a deregulatory measure and one that does not provide any basis for deregulation. That's slightly hard to understand the claim in the Bay's press release that the bill gives the opportunity to the United Kingdom to be bolder and go further than the EU in passing new rights and protections. It's slightly difficult to reconcile that with the text of the bill.
Well, that was incredibly helpful. I think in light of the time, we should move on to some substantive legal changes that the bill also proposes.
Can I just say one thing, Jack?
Go for it.
And it's partly to do with a question that's in the Q&A. But I, for one, would be enormously surprised if this part survived the House of Lords unscathed. We already had a remark from one of their lordships in a slightly different context of the Northern Ireland legislation with the protocol, that these provisions are Henry VIII on steroids. And so you could imagine that there's going to be a very high level of scrutiny and objection in their lordship's house.
Yes, absolutely. I couldn't agree with that more. Then turning to the substantive legal changes, I think it takes us slightly out of order, but if we start, I think, with clause 7 about retained case law, rather than the substantive assimilated law changes which come at the end of 23, because it strikes me that it's possible for clause 7 in relation to case law to be commenced and apply before then. So trying to take it in time order. Now, clause 7 amends section 6 of the EU Withdrawal Act 2018. So it's probably worth my outlining very briefly what the current position is before I ask our panelists to take us through what the new proposed position will be after clause 7 is enacted. So as of today, the general rule is that lower level domestic courts are bound by ECJ case law handed down before IP completion day. So that's the 31st of December 2020. But they're not bound by any ECJ case law coming down afterwards. A court, however, may have regard to anything handed down after the end of 2020, so far as relevant, and that's their discretion. Now, certain higher courts, however, so that's the Supreme Court, the High Court of Judiciary in Scotland, and the Court of Appeal of England and Wales, and the Court of Appeal of Northern Ireland, for example, are not bound by any retained EU case law, so they can depart from retained case law. And the current position is that the test for when deciding whether to depart from retained EU case law is that they apply a test that the Supreme Court decides when to depart from its own case law. Now, there's no actually particular settled formulation of that test. The considerations to be taken into account were set out in the House of Lords practice statement, which stated that a previous decision may be departed from where, and I quote, where it appears right to do so, but exercising caution and taking into account the damage to legal certainty that such a course would entail. So who would like to take us through the new position in clause 7 that may alter some of that?
Shall I have a go?
We can chip in.
Yes, you can. I mean, the new position is that the relevant courts, be it the inner house of the Court of Session, the Court of Appeal or higher, can depart in what is said to be a non-exhaustive list of 3 circumstances. They may, amongst other things, have regard to the fact that decisions of a foreign court are not usually binding, that any changes of circumstances which are relevant to retained EU law have occurred, and that the extent to which retained EU case law acts to restrict what is called the proper development of domestic law is somehow interfering with the processes of this country. I'm reading the version from the explanatory notes, but that's in clause 7 of the bill. It is said to reflect some factors which the Court of Appeal in England took into account in deciding whether or not to depart from retained EU law in a case called Tune In and Warner Music. For my part, respectfully, I failed to identify those words in Tune In and Warner Music, that the court did not depart, of course, in that case. What it did say, which makes it a slightly odd reference, is that by reference to cases such as Horton and Sadler and Peninsula Securities, a court, in that case, the Supreme Court, will only depart with great caution, rarely and sparingly. And Tune In was a case about copyright. There's an international legislative framework to consider. It's a case that doesn't seem to me, obviously, to help very much with what the factors are going to be. So we are left with these new factors, untested. They did say in Tune In, or the court did say, that the English courts ought not to comment too freely on CJEU cases, so as not to confuse the position between retained EU law, where CJEU cases are binding, and new EU law, post-Brexit, where CJEU are not binding in this country anymore. But that's going to be swept away by this legislation. So that can't be it. Tune In was, permission was sought in Tune In from the Supreme Court, so they refused permission. So it doesn't help us enormously. It would be fascinating for lawyers, of course, trying to develop what these non-exhaustive factors are. On the basis of this, they can be almost anything, in my view.
I suspect that the intention is to try and make courts more likely to depart. And I suspect they're trying to move away from that practice direction test, which emphasises, and the case law under that practice direction, which emphasise the importance of the slowness to change from the past case law and due to legal certainty, as you flagged, Flip, but also separation of powers reasons, because of course it's judicial lawmaking in that case. So I suspect that that's why they changed the test. But I have to say, I'm not quite sure it's particularly effective, because this is so open textured, having regard to these 3 factors. And of course, when factors are set out in legislation, they have a bit more weight and relevance. But it seems to me that this list is quite open-ended. And I confess I really don't understand the little c, which is the extent to which the retained EU case law restricts the proper development of domestic law. That, to my mind, could be essentially anything. And I doubt it's going to stop us as lawyers putting forward EU case law, which is interpreting language which is maybe the same or extremely similar, as maybe not direct precedent anymore, and the courts are not bound to follow it, but at least as persuasive authority of these are what similar words and other courts are doing. So I'm not quite sure in practice what this will change from the Tune In list, which to my mind seemed quite extensive.
I there's also, sorry, Catherine, go ahead.
I was just going to say, I would agree with everything you just said, both of you, but Jack, I think I see this as a nudge to the courts, because I think there was deep frustration in parts of the government about the Tune In list. As Philip helpfully said, there were 8 reasons why they decided not to depart. And I mean, lawyers might say these are all good reasons, but if your view is that we are making a significant break with the EU, therefore caution of that kind is not fitting. But of course, it's very difficult, given the separation of powers, for the legislature to tell the courts exactly how to do their business. And so you've got this sort of If you were charitable, to say a helpful direction. If you were less charitable, you'd say a fudge, which uses quite a lot of words to say, speed things up a bit, guys, thanks.
Yeah, I mean, another way of, I think, looking at that, perhaps looking at the same point at the other end of the telescope, is that it may well put the courts in a somewhat difficult position. I mean, the political context here is as Catherine says, that there is a nudge from the executive to depart from ECJ case law more freely. I mean, I suspect there may be a certain amount of judicial anxiety that if this clause is passed in its current form and they then decide it is appropriate to stick to retained EU case law in a particular and high profile, to stick to ECJ case law pre 2020 in a perhaps a controversial and high profile area like workers' rights or consumer rights, that they will then be criticised by the government for not being daring enough in departing from ECJ case law. So I think there's some of the constitutional concerns about essentially throwing this issue to the courts in circumstances where the government is sort of nudging them rather than actually giving them clear language.
Now, another nudge is the new national reference procedure set out in Clause 7, which is slightly ironic that we are borrowing from our European friends a preliminary reference procedure and implementing it into domestic law. Philip, I know this has tickled your interest very much. So what's a national reference procedure, please?
Oh, yes, well, you say that, but in fact, it's an idea that was first put forward by the former Conservative Lord Chancellor, Lord Mackay, in debates about the withdrawal agreement and the acts, which is that in circumstances where the first instance court cannot depart, but a first instance judge may think this is wrong, this piece of what was EU law, the first instance judge, in cases where it is thought to be of general public importance that she or he do so, may make a reference, a little bit like a reference to Luxembourg, but they would make a reference either to the inner house of the Court of Session or the Court of Appeal in England or Wales, or if it's a Supreme Court case, to the Supreme Court, or the High Court of Justiciary in certain cases, and will make the reference about the retained case law of that court, and they ask the court whether or not it ought to be overturned. And the High Court must accept the validly made reference if, like the lower court or tribunal, it considers the point of law referred is A, relevant to the proceedings and is of general public importance. They then decide the point of law, and then the case returns to the lower court or tribunal, which must follow and apply the decision so far as relevant to the proceedings. Now, this as you say, reintroduces, in a sense, the familiar and perhaps the most creative aspect of EU procedural law, which was references, which came from a suggestion, I understand, based on a medieval and early modern German tradition, or German states, to make references to a university, usually Heidelberg, if there was a very complicated point of law. A state judge would send the question off to Heidelberg, where the wise men of Heidelberg would deliberate and send the answer back. And then the local court in Duisburg or Hanover, wherever it was, could apply it. That was the origin of the reference procedure. Here it is now in our law, which is an interesting example of assimilation of.
How do you think it will work in practice, though? Obviously, the lower courts where this is going to be used can't depart from retained EU law, and the consultation, which we're trying to list the courts which could depart, to specifically raise the idea of, there'll be lots of costs and delay, and everyone will want to be rerunning decided EU case law again and again. And I particularly have in mind the VAT tax context, where there are a number of EU decisions which people may rightly or wrongly disagree with. Does this mean that the proceedings will be ongoing whilst this reference is going up to the Court of Appeal in one example, and therefore add delay and costs into a procedure? And I just wonder how frequently this will be used because of that cost and potential time delay. And not only that, I feel quite sorry for the Court of Appeal or higher court judges having to determine a point of law, very unlike common law thinking and tradition, without actually knowing the facts to which it's applying to in detail and quite where that piece of law is fitting into the legal reason. So I just wonder how often this might be used, or whether clients might think, well, this is costly and a bit of a risk, and therefore we'll just wait to appeal a point of law after the case has gone one way or another.
Well, it's not only the clients, it's also the court of its own motion that is supposed to make the reference. Maybe out of the control of the clients who are paying for it, which is a bit different to a leapfrog appeal to the Supreme Court. I imagine it will have to bed in. I mean, the reason it is so exciting for someone like me is precisely the reason that you mentioned, that we're going to have the opportunity to re-argue all of the cases that we've been arguing for the last 30 years or more, and see if we can change the outcome. Some of them, like, if it's going to happen, yes. Can you hear me?
Yes.
I was going to say, if it's going to happen, it will have to bed in, and it will develop its own system of rules. It may well be that, like the ECJ, the higher court will say you can only make a reference once the facts have been found to make sense. It may also align itself a little, for instance, with the kind of tests that you have for preliminary issues. And as we know, preliminary issues are to be enjoyed with a certain degree of caution, because you can very quickly go down the rabbit hole of a preliminary issue and end up with more costs and nothing resolved. I would imagine courts are going to be very careful.
In light of the time, I suggest we skate over the law officer reference equivalent, which is whereby a legal UK officer can intervene, essentially ask for a reference if a party hasn't done one. I suggest...
Yes, and within 6 months of the end of the proceeding.
So yes. After the proceedings, right, I don't know whether parties will therefore be dragged into that unwillingly or unwittingly. But moving to substantive changes as of the end of 2023, so we have this wonderful clause 6, whereby we're in a brave new world of assimilated law, whereby everything that we knew and loved as retained EU law is rebranded to assimilated law, presumably with the function of just removing the EU from our statute book. But I wondered about the substantive differences in this brave new world. And perhaps, Catherine, you could begin with clause 4 of this bill, which is about the abolition of the supremacy principle.
Yeah, well, thank you very much for that. So this is another very fine example of hokey cokey, because if you remember, when we were talking about supremacy of EU law, it was meant to be turned off by the 2018 Act by removing the European Communities Act in Section 1 and Section 5.1 removing supremacy, but then 5.2 brought it back in. It was always something of an oddity, but if you took the view that a snapshot, that's what the 2018 Act was trying to do, then it made sense to have supremacy. Now, what this Act does, much heralded by Lord Frost and others, is to turn off supremacy. Again, you are told this very clearly in clause 4, which is going to be the new capital A1 inserted into section 5. This is going to make the actual reading of the 2018 Act almost impossible, given the number of caveats. And furthermore, not only is supremacy being turned off, we also are told from the explanatory notes that so is the principle of consistent interpretation, and that is paragraph 86 of the explanatory notes. So that is being turned off. There is, however, a carve-out for provisions on data protection in A3. Now, the excitement doesn't stop there, because even though we are told supremacy is being turned off, in fact, it can be turned back on again. Now, you might think, why on earth would this statute, which is meant to be the brave new world of post-Brexit, why on earth can it be turned back on? Well, it does allow departments like BEIS, for example, to turn back on supremacy. In other words, to turn back on the possibility of allowing for Article 157, remember we talked about that on equal pay for men and women, Article 157 being turned off in the sunset, but with the possibility of being turned back on. And furthermore, not only with the possibility of being turned back on, but also with the possibility of having supremacy over conflicting provisions of the Equality Act. So essentially turning off what the constitutional challenge, which you were able to do and still able to do until this bill becomes law, it's turned off, but with the possibility of departments opting back in to do just that. I'll stop there and let others comment. And just if you want to, if you're not sure where I'm talking about, I'm in clause 12, sub 5.
It's another example of the hokey cokey. We turned it all off, but it can be turned back on again.
At one point worth, I think, no, I mean, the example Catherine gave of a possible conflict between the Article 157 of the treaty, which is obviously dates back to the point of accession, as far as we are concerned, and the Equalities Act, which is 2010, and she's absolutely right that the effect of the principle of supremacy there is to make the former, the earlier, supreme over the latter, which is of course the reverse of the way in which acts of parliament normally work. I mean, one thing that's notable, and perhaps might be the sort of thing that perhaps in due course might be a subject of sensible legislative amendment, is that there's no requirement whatsoever for the departments to have done the really quite detailed and probably rather painful work of working out in every particular case what the consequences of making that change are. I mean, you, in order to be absolutely confident about what the effects of making that change are, you'd need to look at each bit of retained EU law and then go through the UK statute book, the elements of which were passed subsequent, and work out to what extent the UK statute book might be inconsistent with the earlier EU provision. As far as I'm aware, nobody has done that and probably is not going to do it. But until you've done that exercise, you simply don't know what the consequences of making that change are.
No, because it changes the normal chronological rule, of course, about which act impliedly over appeals, if possible, earlier acts of parliament. It's now the simple case that domestic law, whenever, is supreme over retained EU law, or assimilated law, I should say. The one point I'm quite keen to draw out from this conversation is buried in clause 22.6, just to make it abundantly clear about what we're talking about and when we're talking about these abolitions. That section states that sections 3, 4, and 5 do not apply in relation to anything occurring before the end of 2023. So really, when we're talking about the abolition of supremacy and when we get to abolition of general principles, it's all forward-looking from that point onwards. If there are cases about facts and matters of today's date and up until the end of 23, we're still in this old world in that case, which means that it's going to be incredibly complicated for that and many other reasons, because lawyers and businesses are going to have in mind lots of different areas of law applying depending on when the facts were actually in question. So I have in mind, for example, we all have to remember EU law for a good few more years because of a potential 6-year limitation period. So if the facts occurred before Brexit, there still may be cases in the courts applying EU law proper if they've been accrued. You then have retained EU law for the period between IPC Day and the end of 23. It then gets changed and converted into assimilated law. And from what you were saying earlier, George, it sounds like there may be divergence amongst the nations in the UK as well. So, and of course, that doesn't even mention separation agreement law, where you have the withdrawal agreement and EU law proper applying for a number of years, and law stemming from the TCA, the Trade and Cooperation Agreement. So there is so much going on. I did some rough calculations yesterday and think for the next 10 years at least, we might be applying quite a lot of different levels and layers of law in applicable in our court cases for at least that period of time, which is incredibly complicated. But moving on to clause 8, because as you were saying, Catherine, you essentially the default position is supremacy is abolished. But my reading of clause 8 is that it's one way in which supremacy can be restated, i.e. retained EU law, like your clause 12.5 reference, can be given supremacy once again, or assimilated law can be given priority once again over domestic law if a minister by regulation makes that decision to do so, which leads to a few conundrums, really.
Yes, I mean, the interesting question is why that is there in the first place. And certainly with this government, it's very hard to see that many cases where they would decide to give EU principles of law hierarchy, except possibly in the area of GDPR, which they clearly see as a carve-out. So it may be that, and this of course feeds into a wider political debate, but yes, but that is the other option. And of course, while you're mentioning general principles of law, do you want to talk about that as well, bearing in mind
Yes,
the time?
Yes. Sure.
So very briefly, general principles of law, you'll remember those are the things like proportionality, legitimate expectations, and crucially, fundamental rights. Now, just going back a stage, the Charter was never, ever part of that snapshot process in the 2018 Act. Not to worry, said the government, the general principles will do the heavy lifting, subject to certain rather significant caveats. The actual legal incorporation of the general principles was never absolutely very clear in the 2018 Act, but not to worry, because now they have all been turned off. But again, as is common in this pattern that we keep seeing, although they have been formally turned off, they can be turned back on again. We're back to clause 12.5, should there be a decision to do that. And that's actually rather important, because remember, general principles include fundamental rights. Charter is not there, but a lot of EU-derived legislation has references to the Charter in the preamble. And of course, the case law of the Court of Justice, which, yes, is not going to be as important, but the case law of the Court of Justice also contains repeated references to general principles and to fundamental rights. So even though formally general principles have been turned off, they might come in via the backdoor route, either expressly via legislation or indirectly via judicial interpretation.
And there is a further just footnote to that it may also come in through judicial discovery of the same principle under the common law. And we've seen that already. So Lord Justice Green identified the principle of effectiveness, which is one of those general principles, as a common law principle in a case called Stellantis. And of course, years ago, Lord Justice Laws identified proportionality as a common law principle in Ex parte Warner back in 2007. So that's another way in which we might find these familiar principles come back in a slightly different guise.
Judicial creativity, it reminds me of about, I think, 2014, when there was a lot of talk about the Human Rights Act being repealed. And there was a lot of case law right up to the Supreme Court level, where essentially the common law discovered or was inspired by quite a lot of the provisions in the convention. And therefore we had domestic case law, which was already on point. And I also was going to mention the Lord Justice Green comment with the principle of effectiveness now applying as a common law principle. Which was most intriguing when you think about its roots, to make sure that EU law rights were not impossible to vindicate. But it'll be interesting to see whether we all see a lot more of that. Now, where we have these different hierarchies which are set out by the new principles in clause 4, you have a wonderful thing called an incompatibility order in clause 9, where a court states that either the retained EU law is incompatible with domestic law or vice versa. And this, it strikes me, as a very interesting provision in clause 9, because these incompatibility orders give the courts huge amounts of discretion as to what order they actually produce when there is an incompatibility between assimilated law or domestic law. I wondered if we had any thoughts about the constitutionality of that, or whether it's a move away from the traditional entre vires principle, where something is held to be unlawful, that knocks down the house of cards, or how we see the incompatibility orders being used in practice? Or will a court really limit or remove the effect of an operation of a given provision that can't be interpreted consistently, where it gives rise to unfairness to individuals, for example, as suggested in the explanatory notes? The mind boggles on clause 9.
Mind boggles, I think. I mean, there were similar discussions of all of this in the context of the government's proposals in relation to judicial review. Generally, the sort of the prospective only order and the circumstances where the courts would be entitled to make such an order, as opposed to declaring that the law was always what it had been, right from the outset. And obviously, it's a notoriously difficult area. I mean, one finds the ECJ grappling with that question in a number of cases where the consequence of declaring a national law incompatible with EU law might be, in some cases, was going to be rather startling.
I mean, there's two things here. First, there's an obvious and probably intentional echo of what happens under the Human Rights Act with the Declaration of Incompatibility, except this time it's a declaration with teeth, as it were. Yeah. And then it is perhaps no different to what we saw in relation to, say, factortame when the Merchant Shipping Act, or whatever it was called, was declared unlawful. Question, how is that going to happen? In fact, the statute was then withdrawn, repealed, but it's logically necessary to have something like that if you have provisions that say that retained EU law is going to be incompatible with domestic enactments. Something has to give, and it's not going to be the domestic enactment.
We shall see. In the time available, I'm quite keen that we don't skimp out on time discussing the effect on devolution, which is a topic which really deserves its whole hour itself.
But 2 minutes.
But in a few minutes, I wondered whether what we've been discussing applies in the same way across the UK. We've already touched on this slightly, or whether there is the potential for divergence.
Yeah, I mean, essentially, the bill talks pretty much passive about national authorities. And that's because national authority is defined as including the devolved ministers as well as UK ministers in areas of devolved competence. There's a whole set of really complicated provisions I won't talk about because I haven't got to the bottom of them and they're too complicated anyway, of what to do in areas of shared competence. But in areas where a devolved minister has sole competence, all the powers that ministers have under the bill will be conferred on them too. I think we as we mentioned earlier, the devolved ministers will have access to the power to use an awful term, de-sunset bits of retained EU law that would otherwise be sunsetted, that using the clause 1, 2 and clause 2 powers. I don't myself see why they couldn't simply decide to de-sunset everything, given the width of the power that is there. I think there's an interesting question as to whether they could legislate to stop the consequences of the provisions we've just been discussing on interpretation of and hierarchy of what will become assimilated law in their areas of devolved competence. I mean, they will have the power that we were discussing earlier, the clause 8 power, to maintain the existing hierarchy. And I suppose, again, they could just decide to do that fairly uniformly if they thought it appropriate. I don't see, however, how they could legislate to change the interpretation provisions that we've been discussing, the powers of the courts to depart more freely from retained EU law interpretations and the switching off of general principles. And I think the reason why I think that is that the relevant provisions are all put into the EU Withdrawal Act, which is a legislation that is in the schedules to each of the devolution acts, that lists legislation that cannot be modified by the relevant legislature. So I think the relevant legislature is stuck with that. However, one option that would be available to a devolved minister that was absolutely determined to stick as closely to EU law as he or she possibly could would be to restate or replace the bit of retained EU law that would otherwise be sunsetted with a new piece of legislation that would be domestic legislation and not subject to this bill at all. But that domestic legislation could say, as a matter of domestic law, that it was to be interpreted in accordance with principles laid down by the European Court of Justice and to follow European Court of Justice case law. For those of us who do competition law, that's sort of slightly redolent of the position that obtained for a while under Section 60 of the Competition Act, which was entirely domestic law, but which chose, as a matter of domestic law choice, to bring in principles of EU law and the case law of the ECJ. And I certainly wouldn't have thought that it's politically inconceivable that devolved ministers, certainly in Edinburgh, might feel that that was something they wanted to do. And so that seemed to me to be the route by which they would do it.
Splendid. So I think we have time for a couple of one-line answers to some of the questions which have been put into the box, which Catherine is going to guide us quickly through. And otherwise, we promise to blog some of the other questions that have not been raised, but we'll take them away with us and consider them duly. Catherine, were there a couple that you wanted to?
Yeah. Thank you very much. The questions are fantastic, and of course, all hard law. I'll cherry pick the easier ones. The harder ones we don't have time to deal with now, but we'll keep a note of the questions, and Jack will blog on them, and the rest of us will just sit with a hot towel around our head. Someone's pointed out, isn't it clause 12.6 that switches EU principle back on, not 12.5, and the answer is that is yes. 12.5 lists what the principles are. 12.6 switches them back on if it's chosen to do so. Question about the working time regulations: will they be sunsetted? They will be sunsetted entirely if nothing is done. This is the basic principle of the bill, that everything that is not consciously saved will be turned off by the deadline. And so, depending on your point of view, this is a very quick and effective way of turning off whole swathes of EU law, or you could say it's not a terribly responsible way of managing the statute book, because the default position is everything is turned off unless there's a conscious decision to turn it back on. And yes, it requires ministers to act and it requires them to think proactively. But the bottom line is, if nothing is done, everything is turned off.
Can I say a very short thing about one of the questions, because somebody said that commercial agents regulations were mentioned, and they were indeed mentioned, and they give rise to an interesting problem which illustrates the wider, possibly unintended effects of this legislation, which is, under the regulations, you're entitled to a statutory payment upon termination of your agency. It's something that works into private contract law from legislation. So it's a crossover piece of EU legislation for the protection of agents. And you can, in the contract, select indemnity instead of compensation. What if somebody in their contract has selected indemnity, then the sunset happens, the regulations disappear. Is that indemnity still payable? And it may well be a question of how it was worded in the contract. Was it worded to say, insofar as they apply, the regulations should provide for an indemnity, or was it worded simply to say, when its contract ends, you get an indemnity? And I'm not going to venture the answer, but actual legal advice is available as and when.
Somebody asked a question which always piques my interest when everyone mentions the Northern Ireland Protocol, as how this affects the Northern Ireland Protocol. I mean, the short answer is it doesn't at all. As Jack said, the Northern Ireland Protocol is withdrawal agreement, separation agreement law, and is not affected at all by this bill. You need to look at the Northern Ireland Protocol bill for that. obviously, to the extent that it promotes and as it is indeed designed to promote and encourage divergence between UK and EU law, that throws up a whole series of legal and practical issues in terms of the administration of the protocol, and that is an issue. I think more broadly, I think there has been quietly a certain amount of anxiety expressed about this in on the other side of the Channel and the other side of the Irish Sea, in terms of the level playing field provisions in the Trading Cooperation Agreement. And I think all that can really be said about that is that the EU will obviously be looking quite hard at what actually comes out of this process. And it's impossible to be precise about what will come out of it, with a view to seeing whether it's appropriate to invoke those level playing field conditions if it feels that protections in the areas covered by those provisions have been reduced to an unacceptable level.
Well, on that absolute bombshell, I think it's my duty to thank our presenters, Philip, George and Catherine, for a truly wonderful and very eye-opening talk. I've learned an incredible amount, so thank you very much for your time. And thank you very much for switching in. I think we've had a record attendance on this webinar, so it just proves that there are a lot of questions of this bill. I hope we've answered the majority of them, and we'll probably come back once it's an act and it's all changed yet again. But thank you very much for your time.